edges of our courtroom. It is my absolute honor to introduce our expert mentor for the day, Mr. Suvigya Saxena, sir, who is a scholar of the highest caliber. He is currently a Ph.D. scholar in law at Uttaranchal University and holds a Master of Law in Constitutional and Administrative Law from the prestigious Damodaram Sanjeevaya National Law University, Visakhapatnam. But what makes him the perfect guide for today is his experience in the trenches. He has practiced as an advocate for 2 years, dealing specifically with very topic we are tackling this week, this honor of cheques, along with matrimonial and criminal matters. Here is a unique legal mind whose interests converge constitutional law with spirituality, bringing a depth of philosophy to his legal practice. In turns, you are in safe and expert's hands. Please get your notepads ready. Sir, on behalf of the Nyayavani Foundation and this spring cohort, we welcome you. The virtual podium is yours now. Sir, you may start.
Okay, thank you. I think my internet got stuck. So, thank you for such a nice introduction. um, and I thank the entire team of Nyayavani for inviting me to this webinar. Now, the topic that I have been given is regarding this Negotiable Instruments Act, specific to the dishonor of check. I would like to present a PowerPoint presentation so as to make you people understand. Mm. No. Actually, I am unable to share. How can we do it? Actually, can you please help me out?
Sir, I am sharing the PPT.
And do you have? Wait.
Yes, I just send you the. Are you talking about the sample demand
No,
notice
no,
line?
no, no. I am not talking about that. That is a
Uh,
different. Uh,
okay, sir, you send me on the WhatsApp. I'm just sharing on the screen.
sure. I have shared it with you. Can everyone please confirm if I am clearly audible or if there is any noise around?
Sir, you are perfectly audible.
All right. Great. So the topic that we have is Negotiable Instruments Act 1881 and the practical insights, the procedures, and the contemporary issues. So we'll focus here mostly on the how things are done and the procedures part, and the issues are the issues and challenges that a person faces in this kind of litigation can be best understood when you step into the practice. So it mostly relates to the loopholes that are being exploited both by the advocates and the litigants. So can you please proceed? Next slide. Yeah, this one. So before proceeding, we must know what is negotiable instrument. So it's a document that contains an undertaking to pay or an order to pay a money to a certain person. Why is it called negotiable? Because the term negotiable, it identifies with transferability. So any document that contains an undertaking or an order to pay some money that is transferable by way of an endorsement and delivery. So I would like everyone, if you have a Barrect in hand, or if you have a digital Barrect open in your phones or in your laptops, that would be better. You just see section 13 and section 14, which talks about negotiable instrument and as well as the negotiability or the negotiation. You just look into it, you'll get to know what is a negotiable instrument. So it is simply a document that contains an undertaking to pay the money. The types of negotiable instruments that are discussed in the NI Act are of three kinds. First is the promissory note, second is the bill of exchange, and third is the check. What is I'll just deal with the promissory note and bill of exchange in a very brief, and we have a detailed discussion on check thereafter. So a promissory note is mentioned in section 4, and if you read that, you'll get to know that it is not a banknote, it is not a currency note, whereas it contains an unconditional undertaking or a promise to pay certain sum of money to the bearer. Why the banknote or currency notes are excluded from this category? If you would have ever looked at that carefully on a currency note, suppose a 100 rupee note, you would notice there is a line that is written which says, I promise to pay the bearer this certain amount of money. मैं धारक को 10 रुपए या 100 रुपए अदा करने का वचन देता हूँ. What is this line? This line is a promissory line. It undertakes, it acknowledges that a person who is holding this particular currency note, he is having that particular value in his hand. But the promissory note excludes the currency notes. So what does it talks about? Any document that contains an unconditional undertaking or a promise. It has to be signed by the maker of that promise. It has to be in writing, and there has to be an express promise to pay. And one more thing is, the parties that are involved are two. One is the maker, who is the debtor, and the other one is the payee, who is the creditor. Now, if you look at the illustrations to section 4, which talks about promissory notes, there is illustration A, which says, I promise to pay B or order rupees 500. There has to be specificity that there is a promise to pay. All right. So I suppose all of you must be having a Bear Act. Can anybody please respond?
Am I audible?
We have just shared the Bear Act, sir. They have the Bear Act.
All right. All right. All right. Then it's good. Then it will be very easy. Yeah. Anyone, is anyone asking something? No. All right. So can you please move on the next slide? Now, the second thing that we are considering is the bill of exchange. What is the bill of exchange? Now, it is not similar to a promissory note. Promissory note just contained an unconditional undertaking or a promise, whereas a bill of exchange is an unconditional order. Now, you must be aware of the difference between an order and a promise. All right. Again, order is you give an order to a person, to a third person. Similarly, in this case, in the case of bill of exchange, there is an unconditional order. Unconditional, why? There should be no condition. Suppose I order to pay particular person rupees 500 when he marries. Now there is a condition. What if he doesn't marry? I won't be paying him 500 rupees. So that is why the term used is unconditional order to pay. Again, what are the essentials here? A bill of exchange must be signed by the maker or the drawer. Then it must be in writing. And again, it must have the express order to pay. Now, all right, I'll make you understand. The parties that involved are three parties: drawer, drawee, and pay. You want? Can you please? Okay, wait. Take note of section 4. It talks about promissory note. It contains an unconditional undertaking or a promise. It simply is a promise to pay that, okay, I promise to pay you this particular amount. Whereas in a bill of exchange, I would say that I order to pay this particular person to this I order to pay this particular person this particular amount. The essential difference here is, in a promissory note the parties are two, whereas in a bill of exchange the parties involved are three. When there are two parties, suppose I and Mr. Asif are there, and I promise to pay Mr. Asif rupees 500, and I sign a document and I hand it over to him. So that becomes a promissory note. Whereas when I'll draw a bill of exchange, there will be a third person involved. Suppose a person C is there. Now I'll order this person C, I'll hand over him 500 rupees and an endorsement where I will be writing that I order to pay Mr. Asif rupees 500 upon demand. All right. So that becomes a bill of exchange. Now, when Mr. Asif will take this document to person C and he produces that document, the person C will be bound to pay him the 500 rupees. So I suppose this would have made some things clear. Please respond yes or no.
Yes, sir.
All right.
Yes, sir.
All right. All right. Now, when we move on to the check. Check is a bill of exchange drawn on a specified banker payable on a demand. I believe all of you must have seen a bank check. You guys must be at least of the age 18 to 24 or 25. Yeah. All of you must have seen a check and a demand draft as well. When both of these, we'll address all these questions afterwards for sure. Both of these check and demand drafts, they form the part of bill of exchange. So bill of check is also a bill of exchange drawn on a specified banker payable on demand. So a check is issued to a customer of the bank on his account, and all right. I request everyone, if you have a doubt, we'll address all the doubts in the end of the session. Will that be okay, Mr. Asif?
Sure, sir. The Q&A session will be at last, so You can take the question at the very last. For now, you just explain the topic.
Yes, yes. So I was talking about check. So it is again a bill of exchange drawn on a specified banker payable on demand. So all checks are bill of exchanges, but all bill of exchanges are not checks. This you must keep in mind. So even a demand draft is a bill of exchange, but it is not a check. Again, the parties involved in a check are three parties: the drawer, which is the person signing, the drawee, which is the bank, and the payee, which is the check holder. Yeah. So the parties involved are three: a drawer, a drawee, and a payee. So check is a bill of exchange drawn on a specified banker payable on demand. All right. Uh, can we move on to the next slide, please? In this particular topic that we are dealing today is we are talking about the dishonor of check, uh, section 138 and section 141. I'll be dealing with particularly section 138. 141 is identical, and it particularly talks about the companies or the personalities, legal personalities. All right. So what is dishonor? Dishonor means when a check is returned unpaid. Now I'll explain you with a situation. There are two people, suppose, yeah, Mr. Asif and myself. I draw a check of rupees 5 lakhs to Mr. Asif. My bank is Punjab National Bank, and I pay that check to Mr. Asif. For this is for a consideration. Suppose Mr. Asif is maintaining a firm that deals in the sales of television. So I purchased a television of rupees 5 lakhs, amount rupees 5 lakhs, just for the sake of it. And instead of paying in cash, I paid him the amount by check. I entered the amount in check 5 lakhs. I handed over the check to Mr. Asif. When Mr. Asif went to his bank, he produced the check within the time limit, and the check was returned to him with a notice that there is insufficient balance in Mr. Saxena's account. So this particular situation is called as dishonor. When the check is returned unpaid, Mr. Asif is returned with a notice. He doesn't have the cash rupees 5 lakhs in his account or in hand. Now this particular thing is an offense, which it is made an offense. इट इज मेड एन ऑफेंस। जी मैं आपके लिए हिंदी में भी बता देता हूँ थोड़ा सा। जैसे मैं और आसिफ जी जो है, आसिफ जी जो है एक टीवी की दुकान चलाते हैं। मैंने 5 लाख का टीवी खरीदा और उनको जो है मैंने 5 लाख रुपए ना दे करके चेक दे दिया 5 लाख का। ठीक है। और उसके बाद जब वो अपने बैंक में गए, उन्होंने चेक को प्रोड्यूस किया वहां पर इनकैश कराने के लिए, तो चेक जो है रिटर्न हो गया और उसमें कहा गया, रीजन दिया गया कि मेरे अकाउंट में, मिस्टर सक्सेना के अकाउंट में सफिशिएंट बैलेंस नहीं है, यानी मेरे अकाउंट में 5 लाख रुपए नहीं है, जिसकी वजह से उनको भुगतान नहीं किया जा सकता है। तो ये जो सिचुएशन आई, इसको हम कहते हैं डिसऑनर। हिंदी में इसको कहते हैं अनादरित होना, आदर ना होना या अनादरित होना। आई आई सपोज, मुझे लगता है आपको समझ में आ गया होगा जो भी हिंदी में है। मैं थोड़ा बहुत कोशिश करूंगा कि हिंदी में भी लेकर चलें, बिकॉज वी ऑल्सो हैव सम इंटरनेशनल स्टूडेंट्स हियर, सो विल हैव टू डील विद बोथ ऑफ यू। ऑलराइट, या। Now, what is the object behind making this particular thing as an offense? इसको एक आपराधिक श्रेणी में क्यों रखा गया है? इसके पीछे की वजह क्या है? So, the court says in Manoj K. Seth versus R.J. Fernandez, although there are n number of cases reiterating the same, it says that to enhance acceptability of checks by making a drawer liable for penalty in case of dishonor. Hello. Is there a question? No. All right. So, what does it talks about? To enhance the acceptability of checks by making a drawer liable for penalty in case of dishonor. Now, suppose if there was a system, if there was no penalty upon such a dishonor, I would have paid Mr. Asif a check and my liability would have been discharged. Although he hasn't received the sum of rupees 5 lakhs in his hand. So he remains unpaid. He remains cheated by me if there is no liability. So therefore, section 138 ensured that a piece of paper that I am handing over to Mr. Asif for the payment of his debt or for the payment of my liability, um, that is actually paid and it is not taken for granted. That is the object. मतलब सीधा सा ये है कि अगर इसके पीछे आप आपराधिक श्रेणी नहीं लगाते हैं, इसको आप आपराधिक श्रेणी में नहीं डालते हैं, इस पर्टिकुलर चीज को, तो इसका मिसयूज वैसे तो ऑलरेडी अभी भी हो ही रहा है, लेकिन इसके अलावा भी बहुत तरीके से और ज्यादा हो सकता था। उसका जो दायरा था वो बढ़ सकता था कि मैं खाली एक पीस ऑफ पेपर ही रह कर वो बनकर रह जाता और मैं किसी को भी कोई चेक देता, भले ही उसका पेमेंट हो या ना हो, मेरा काम खत्म हो जाता। सो दैट इज वाई द स्टैट्यूट सॉट कि it should be made an offense. What are the ingredients when an offense is said to be made under this particular section 138? So there must be a dishonor of check. First of all, there must be a dishonor of check, and the check dishonored should have been drawn by the person for discharge of legally enforceable liability. Again, what is legally enforceable liability? I suppose you must have at least read about this in contract. Legally enforceable agreements are termed as contracts, right? So, um, yeah. So, what is legally enforceable liability? I purchased a television from Mr. Asif, and in lieu of that, the payment of consideration I did by the check. Here, what we are talking about is the liability that I have is of the purchase of goods, and for which I need to pay money uh, in lieu of the purchase of that television from Mr. Asif. Foreseeable liability. What if suppose now I won't take the example of Mr. Asif and myself. I'll take A, B, C for this particular example. Uh, there are three persons, A, B, and C, and Mr. A tells Mr. B that you murder Mr. C, for which I'll pay you rupees 1 lakh. And for that, Mr. A hands over a check of rupees 1 lakh to Mr. B. Whereas when Mr. B murders Mr. C and he produces the check received from Mr. A to his bank, and that gets dishonored, will this be covered under a legally enforceable liability? Just
No.
yes, that is the point. So that is where we talks about that is when we talk about legally enforceable liability. It has to be valid. It has to be good in the eyes of law. Only that kinds of liabilities are legally enforceable liabilities. So there must be a dishonor of check, and the check dishonored should have been drawn by the person for discharge of legally enforceable liability. For the person who I'll explain this in Hindi as well. So ए बी और सी के बीच में मतलब ए और बी दो पर्सन थे, और उन्होंने जो है ए ने बी को कहा कि आप जाकर के सी का मर्डर कर दीजिए, मैं इसके बदले में आपको 1 लाख रुपए दूंगा चेक के माध्यम से। और जब उन्होंने बी ने सी का मर्डर कर दिया और चेक के माध्यम से जो उनको 1 लाख रुपए मिलने थे, जब उन्होंने वो बैंक में चेक लगाया तो चेक डिसऑनर हो गया। अब क्या वो पर्टिकुलरली इस सेक्शन में डिसऑनर ऑफ चेक का केस बना सकते हैं? नहीं बना सकते। Yes, yes, I know. I am trying to explain both the things in Hindi. I am trying to explain both in English and Hindi. So Yes. Now, the third point, the third ingredient here is the check is presented within its period of validity. This is again one more important thing. Suppose, what's the date today? It's 7th of December, right? I drew a check dated 7th of December and I handed it over to Mr. Asif. Mr. Asif has a time period of 3 months from today's date, that is 7th December. 3 months, it translates to 90 days. So 90 दिन के अंदर उनको ये चेक जा करके बैंक में जमा करना पड़ेगा. He will have to deposit this check or he will have to present this check before the bank within 90 days or within 3 months. All right. The statute talks about 3 months. It doesn't talk about 90 days, but usually we take it as 90 days. So 3 months is the period of validity of a check. If he goes on the 91st day, or if he goes on the first day of the fourth month, the check has expired. It has no validity. The amount written will not be paid. And such a return of check will not amount to the offense under the dishonour of check, section 138. So this is again very important thing, that the check must be presented within its period of validity. Now, dishonour must be for the stated reasons, that is, funds if insufficient and amount to be paid exceeds the drawer's arrangement with the bank. There is a limit on withdrawal. I would like everyone to just look at section 138 in your barracks. If you have it in hand, it's very good. You can mark as well. I'll read this section, and wherever I take a pause, you just draw a slash there so that you know where to break the particular section. Um, is it okay? Is it workable for everyone? Are you guys having it in digital, or a few of you are having it in hand as well? All right, that's great. That's great. So I'll read the section 138, where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part of any debt or other liability is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank. Such person shall be deemed to have committed an offense and shall, without prejudice to any other provisions of this act, be punished with imprisonment for a term which may be extended to 2 years, or with fine which may extend to twice the amount of check, or with both. Here I've taken pause at a few places, if you may have recognized. So the first pause was after the drawn by a person. Where it will be drawn? It will be drawn on an account maintained by him with a banker. For what purpose? For the payment of any amount of money. To whom? To a person, to another person. From where that money will be paid? It will be paid from out of the account that he is maintaining with the banker. For what purpose? Again, it is for the discharge. For discharge of what? Discharge of any debt or any other liability. And when such check is returned by the bank unpaid, what are the reasons listed? The first reason is there is insufficiency of the balance in the account so as to honor the check. And the second reason is it exceeds the amount arranged to be paid from the account by an agreement made with the bank. How will you understand the second reason? First of all, amount to be paid exceeds the drawer's arrangement with the bank. Now suppose I have an account with the Punjab National Bank, and the withdrawal limit for me in a month is rupees 5 lakhs. I cannot withdraw more than 5 lakhs from an account. मेरे पास एक account है पंजाब नेशनल बैंक का, और ऐसे accounts होते हैं जिन पर लिमिट्स होती हैं कि आप एक महीने में इससे ज्यादा आप कैश विड्रॉ नहीं कर सकते हो, या कैश आप किसी का लेन देन नहीं कर सकते उस पर्टिकुलर अकाउंट से. सो देयर इज अ लिमिट ऑन दैट अकाउंट. Yes. So that particular thing is the slide. Um, all right. This is yeah, this one. The previous slide, please. Yes, yes, yes. Dishonor of for the stated reasons. So there are two reasons. First, there is the insufficiency of funds, and second is there is a limit on withdrawal. And the last ingredient is there has to be a demand notice sent to the drawer of the check, and there is a failure of drawer to pay, and there is a failure by the drawer to pay the demanded amount. So these ingredients must be satisfied, the listed ingredients must be satisfied, and only then the offense is set to occur. Can you please proceed to the next slide? Now there are other situations. We have the statute deals with two situations, but we have we have other situations as well where a check may be returned without paying the amount. If such a check is returned for the reasons stated herein, it will not be considered as an offense. Sure, we'll do that. We'll do that. But first of all, I need to, complete this, what I'm going to tell you. That is important for your internship. So, yes, we'll deal with it. So situations where check may be otherwise dishonored. If you must have ever come across such a situation, there is an endorsement. There is a return of check with a notice stop payment or stop check. So this kind of dishonor of check is guided by the drawer of the check himself. So such a payment is countermanded by the drawer. Now suppose I paid a check of rupees 5 lakhs to Mr. Asif, and thereafter handing over the check to Mr. Asif, I called my bank and I said that particular check number, if it is produced before you, you please do not pay the particular amount to the person producing it. So considering my request, because it is my account, my check, the bank will agree to it and it will not pay the amount whenever Mr. Asif will produce the check to the banker. जैसे सपोज कीजिए मैंने 5 लाख का चेक मिस्टर आसिफ को दिया, और इनको हाथ में चेक देने के बाद ये जब चले गए तो मैंने बैंक को कॉल करके बोला कि फलाना फलाना जो नंबर है चेक का, अगर उसको कोई भी लेकर के आता है तो आप उसको पेमेंट मत कीजिएगा. और बैंक मेरी बात मानता है, और उसके बाद वो जब उनके पास मिस्टर आसिफ पहुंचेंगे बैंक के पास और चेक जमा करेंगे तो उनको पेमेंट नहीं करेगा, उनके पास नोटिस दे देगा कि the payment has been stopped by the drawer of the check, that is by Suvigya Saxena. All right. So since ये जो condition है, this condition of stop payment is not covered under the statutory liability under section 138. It covers only two categories: insufficiency of funds, or if there is a withdrawal limit. The other situations where a check may be otherwise dishonored is when the bank receives the notice of death of the drawer, and or of the notice of insanity of drawer, and the notice of the drawer's insolvency. When does the cause of action arises in case of a dishonor of check? So when the time of demand notice lapses, 16th day, and the demand for payment is unfulfilled by the drawer. We'll understand this procedure in the later on in the slides in very detail, and there you will understand what this demand notice is, and uh, uh, how we proceed further in filing of the cases. All right. Now, where the cognizance is taken under, it is taken under section 142. So the payee or the holder of the check, he must file a complaint. The work doesn't end by serving a demand notice to the drawer. The work completes only after filing a complaint. But when the complaint has to be made, it has to be made within 1 month or 30 days from the lapse of the 15 days notice period. And before where it has to be filed, it has to be filed before the competent court, which is the metropolitan magistrate or the judicial magistrate of first class. Can you please proceed with the slide? Next slide. Yes, the kind of liabilities that arises upon dishonor of check. So the two kinds of liabilities arises, and these are simultaneously arises. First is the civil liability, second is the criminal liability. So there is a simultaneous rising of these two liabilities whenever a check is dishonored. Civil liability is as soon as a check is returned, I become liable, I become a debtor. I become a debtor of the position, and since we are taking example of Mr. Asif, he becomes a creditor. So he can file a civil suit to recover that rupees 5 lakh money, as well as simultaneously he can file a criminal proceedings under section 138 of the Negotiable Instrument Act for the dishonor of check. What is the punishment prescribed? It is term extendable up to 2 years, and fine is up to twice the amount of check, or both. That is the imprisonment as well as the fine. Can we please proceed to the procedure? Yes. Now, this is important for you when you go into the field and a client comes. How does it happen? Suppose I paid sorry, yeah, I paid a 5 lakh rupees check to Mr. Asif. He produced it to his bank. It got dishonored. Now, first of all, it is the duty of Mr. Asif to produce that check within the period of the validity of that check. That is within the 3 months of the date of drawing. And then once it is dishonored, what will he do? He'll panic, of course. He'll panic and he'll go to an advocate. He'll find an advocate. Now you are an advocate. All of you are an advocate in this situation. And you see Mr. Asif running and coming to you, and he says, uh, uh, I am being cheated. And the person, he took a television, he purchased a television, and he gave me this 5 lakh rupees check, but the check is now dishonored. Now, how do I recover my money? Now, you, as an advocate, will calm him down, and you will say, first of all, we won't just go and file a suit. We'll give him time. We'll give Suvigya Saxena a time of 15 days that he will pay you 5 lakh rupees. And if he doesn't pay 5 lakh rupees in those 15 days, the 16th day we can file it. So are you understanding this? The cruciality lies in these time periods. If there is a delay of even 1 day, and if it is noticed, a complaint at any stage can be dismissed. That is the procedure. So as an advocate, you have to be very careful with the time limits. Your client, whoever is your client, he must have produced the check within the validity of that check. And once that particular check has been dishonored, suppose it got dishonored on 10th of December, all right, which is the upcoming date. So the statute says that within the 30 days from receipt of notice of dishonor, that is suppose on 10th of on 10th of December, the check is dishonored, and you received the notice of dishonor from bank on the same day, that is the 10th of December. So from 10th of December onwards, till the lapse of 30 days time period, this 30 days, within the 30 days time period, which is 9th of January. This is again crucial. Why? Because December is 31 days. So whenever such kind of things happen, we count by hand. That is the safest option to do. um, if suppose it's February, you won't just say if it is 10th of February, so the 30 days would be 10th of March. No, it won't be 10th of March. We'll have to count it, particularly count it, that when will be 30 days complete. So within those 30 days, you will have to send a demand notice to the person uh, who has drawn the check, or whose check has been dishonored, and that particular notice has to be of 15 days. Now suppose Mr. Asif went to you, and he complained that the check that I received from Suvigya Saxena got dishonored on 10th of December. He came to you on 15th of December. Already 5 days are lapsed. Already 5 days are lapsed from the time period of 30 days. You as an advocate will not waste a time. You will draft a notice of demand to Suvigya Saxena, that is myself. And you'll say that just as you will receive this, yes, you can particularly, yes, here it is. This is a particular case where everything is actually written. So notice has to be issued within 30 days. And the 15 days notice period starts when, now suppose on 15th of December, he he sent the particular notice by post, and it got received to me on 19th of December. So from 19th of December, my 15 days notice period starts, or 20th, suppose take for example 20th of December, my 15 days notice period starts, and it will end on 4th of December, 4th of January 2026. That and if in those 15 days, if I pay Mr. Asif the demanded rupees 5 lakhs, then there will be no liability upon me. But if I fail to pay, then from 5th of January, he will have the authority to file the complaint under section 142 before a competent court, that is the judicial magistrate first class, against me. So he'll file the complaint, and that too, from the 16th day onwards, it has to be done within 30 days. This you need to keep in mind every time you are drafting a notice. So these timelines you have to be very strict with. Now this is Mahadevan Sunil Kumar versus Bhadran 1991 ka case hai. So when the check is dishonored, and a notice of demand to the drawer must be issued by the payee. Notice to be issued is to be done within 30 days of the receipt of the dishonor of check notice from the bank. Then the 15-day notice period starts when notice received by the drawer, that is the person who drew the check. When he will receive that, then it will be. Yeah, we will take the questions afterwards for sure. Notice must be issued to recover amount covered by the check. It cannot say that 5 lakh ka check tha, and you cannot demand in demand notice that the person should pay you 6 lakh rupees. The amount entered in the check should only be demanded in the demand notice. Now when the drawer fails to pay the amount within 15 days, the cause of action arises and the payee can file a complaint before the competent court. Can we please proceed? The next slide.
Sir, for this, I think I have the English one. So can you explain that? The
Yes, yes,
exact
yes.
one.
Yes. We can share it with the people. I just want to have you shared it with them? They can open it.
Uh, yeah, sir. Just sharing them.
Yeah, sure. Please do that.
The word has been forwarded. Everyone is requested to open that one. I am too sharing here.
Just try that both the screens run parallel if that is possible.
I'm trying, sir. I'm trying. That will.
All
I
right.
think it's okay now.
Yes, yes, yes. So here is a notice before your screens. Now, if you could just look at the no, it got yes. If you could see what are the ingredients of a notice, what is essential. So there has to be the names of the parties fully disclosed with address. So party to whom the notice is served is at the top. If you could see, this is particular of a firm and the proprietor himself. All right. Then what is the other thing followed by the parties? Is the facts and details of your particular problem. So here you will narrate the story that okay, I purchased a particular TV for rupees sorry, you purchased a particular TV for rupees 5 lakhs, and in lieu of that you handed over a check of rupees 5 lakhs to me. When I produced that check got dishonored, and this kind of story in a proper legal language you will narrate in your notice briefly. What all things you need to keep in mind? In my draft, the Hindi one, which is the original one, it is, yeah, he's also underlining it. You need to demand the amount which is covered by the check. There has to be a specific demand. You should open how much rupees was there, and when you will demand it in the end, that needs to be the same amount. Then also the account number that is being on which the check was drawn, the date of the drawing of the check, then the number of the check, the bank of which the check belongs. So all these details must be there in your legal notice. Then at the last, what is important? It is utmost important that you mention the specific period of 15 days. Although the statutory requirement is not that, but for the safe side, what we do, we specify in the notice itself to the noticee that, okay, you have just 15 days time period to return my amount to me. That is whatever the amount is. For us, we have chosen 5 lakhs for that. And we must also specify that if the person fails to amount entered, the amount demanded, on the 16th day or within the 15 days, then on the 16th day, I will just file a complaint before the competent court or the magistrate. These three things need to be there in your demand notice. This is utmost essential. All right. And then you end it by the person who is sending through the advocate. The name of the advocate should be there. All right. So this is the a format of a legal notice or the demand notice. Now, once this notice reaches to the person, can we come back to the slide? Yes. Uh, I would like to can you please take us to the procedure part, the seventh slide? Yes. Now, when the notice is served and the 15 days time period is lapsed and there is no response, or if there is a response, it is not satisfactory response, then the person who has sent the notice, he will proceed with filing the complaint. So, and the complaint has to be filed before the competent court within the 1 month of the period of expiry of the 15 days notice period. So that's all from my side. I am concluding this session. I will take up the questions now. Yes.
Just a moment, sir. I am giving you the questions. Okay. Sir, there's a question. Please explain functions of the parties involved.
Functions of the parties involved. All right. So for a check, there are three parties. One is the drawer, the other one is the drawee, and the third party is the payee. Now you understand it like this. The drawer is the person who draws the check. Suppose that I am the person who is a drawer of the check. Now this check, the particular check, it belongs to me. Uh, it is issued by the bank to me on my account. We all have an account in the bank, and on that account, the bank, upon my request, will issue me a checkbook. So every check of that checkbook, it belongs to me. Now, whenever I will write that, suppose I pay 10,000 to Mr. Asif, so I become the drawer of the check. Who is the drawee? The drawee is the bank. Drawee is the bank. And Mr. Asif, who holds the check, he is the payee. Since he is having the check and in his name the check has been drawn by me, he is the payee. Whenever the payee will go to the drawee, he will produce the check before the drawee. The drawee will just look at the check and he will verify whatever the things are, and then he will hand over whatever the amount is written to the payee of this particular check. That's how the things work in the parties that are involved are. I suppose now.
Uh, yes, sir. There's another question. Is this bill of exchange equals to the unpaid seller bill of exchange in the Sale
Sorry,
of
sorry.
Goods Act?
Yes.
Sir, she's asking, is this bill of exchange equals to the unpaid seller bill of exchange in the Sale of Goods Act?
Yes, yes, yes. Bill of exchange is similar. There is no change. It is just a
Okay.
category of negotiable instrument that there it is talked about in brief, and here it is just elaborated the category of it.
Tax which can be called
There
with
is
the
one more
correct
question I can
decision.
see.
Sorry.
Must all ingredients be satisfied?
Yes,
Are
sir.
there no situations where satisfaction of one ingredient will be sufficient? No, 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 no. This is very strict. The magistrate, whoever will be entertaining your complaint, he will just look at the ingredients. All the ingredients must be satisfied. In the slide itself, I have mentioned all the ingredients. So there has to be all those ingredients in your complaint. If any one is absent, the complaint will be dismissed without entertainment, for sure.
Sir, there's another question, very interesting. Sir, within 15 days, is it necessary for the peer to pay in cash or he can give another check?
Mhm. If he gives another check and if it again gets dishonored, the same thing will continue. Now, the person need not actually. Yes, actually, it's an interesting question. So there have been situations in practice as well, where a person, he again gave the check, and the second one also got dishonored. Now, in that situation, what was done? We we simply proceeded with the previous check itself. The complaint was filed, and upon consultation, we did not just proceed with the other another check that was dishonored, although it was again used as an evidence to clarify that the person does not have an intention to pay my debt. So these things work that way. Even though since it is dishonored, another case can be filed, but since the grounds will be same, that won't be carried on.
Okay. So next question is, if the check was of 3 lakh rupees, but the payer suffered a loss of 50,000 rupees due to late payment, so can he demand 50,000 rupees while sending the notice stating his losses?
If the check was of rupees 3 lakh, but the payee suffered a loss of 50,000 due to late payment, I do not get the question. So can he demand 50,000 while sending the notice? No, actually, okay. That's not important. What is important is, for this particular section, the amount that is entered in check can only be demanded. Now, if you have incurred or if you have suffered a loss of 50,000, a civil liability arises, and you can definitely go for a civil suit. You can recover your amount or your damages from then on. You need not go in section 138. So that is why I also told you about the simultaneous liabilities. There is a civil liability as well as a criminal liability, and both the liabilities are simultaneous. So when a case is under section 138, is a complaint is filed in the section 138, a civil suit for recovery of that money may also be filed under the civil liabilities of the person.
So next question is, why not all bills of exchange check isn't legally enforceable liability subjective to interpretation from one person to other?
um, I do not understand this question. Why are not all
So
bits of exchange check? All right. So for a check, just wait a second. Just wait a second. Yes. Now I also explained bill of exchange check is a kind of a bill of exchange. All right. But bill of exchange are of variety. Even a demand draft is also a bill of exchange. So what your question is, why are not all bills of exchange check? Yes, all bills of exchange are not check because in bill of exchange also there are three parties, but um, a party in terminology there are three parties, but in other terms it doesn't matter. It may be that the parties involved are only two, but one of the parties is acting in another capacity as well. So suppose there is a demand draft case. I would just take this example. In demand draft, what you do, you just suppose you have to make a 15,000 rupees demand draft. What you will do, you will deposit the 15,000 rupees to the bank, and the bank will issue a demand draft. the parties actually involved in the transaction would be three. The drawer and the drawee would be the bank itself. The payee would be the person. All right. So that is why, again, that is a bill of exchange, but it is not a check. The parties involved are three, but it may be that a party acts in two capacities. But in check, there are three parties, and the parties, the three of them are acting independently of each other. There are three actual persons, or there is a bank, and there are two persons. So that's why we can say that all bills of exchange are not checks. So isn't legally enforceable liability subjective to interpretation from one person to other? No, legally enforceable liability isn't subjective to interpretation. Anything that is enforceable legally, it will just cover that. I made that clear with that example, how legally enforceable liabilities are and how uh, illegal liabilities are. That itself turns out to be that it cannot be called as a liability. It will be a crime again if it is illegal. So that is why. Again, if there
Uh,
is a question.
Yes, interns, I will be taking only one question from here because this similar doubt I was having too. Somewhere it matches, and the rest of the question you may ask directly to sir. So the question is that under NIA Act, if defendant doesn't receive summons as he or she changed his address and plaintiff doesn't know about the new address, then what should we do?
Yes, 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 yes. Uh, Excuse me, just a minute. Yes, under NI Act, if defendant doesn't receive summon as he or she changed his address and plaintiff doesn't know his or her new address, then what should I do? You need not do anything. When the complaint is filed and when things are proceeded, there is one thing called as warrant of arrest that is issued. So the police will find him. All right. So wherever he is, the police will find him. Arrest warrant are issued in that case.
Okay, if there any other question from the intern, you can directly ask from the sir.
Yes, yes.
I think there's no more question.
Excuse me, sir.
Yes.
Sir, if a party A pay a 5 lakh to party B, but a party but after 2 months, party A you use 5 lakhs for his personal use and after that when party B try to withdraw money, he will unable to withdraw get money. But then what will be happen?
Again, if that see viewed in this particular section, when we talk about, or when we talk about law in general, we do not generally look at what was the intention or what happened. The reasons are immaterial. The ingredients are material. So if there is a dishonor of check, the offense is made and the liability has arisen and the complaint can be filed. That's it. That is for our concern. As an advocate, you should be concerned about that particular thing, and nothing more, nothing less. All right.
Yeah, Anya, you can ask question.
Okay, I heard when she was saying that all checks are not bill of exchange. All bill of exchange are checks. I want to understand what's the difference between a check and a bill of exchange.
Sorry, is this you who wrote this?
Yes, sir, she's asking that what is the difference between a check and a bill of exchange?
A check and a bill of exchange. So, in science, we read about species and genus, right? And since it's been a long time I studied biology, I believe bill of exchange is genus and check is a species. That's all I can say. It's just a part of it. That's it. Bill of exchanges can be of various types, even a demand draft is a bill of exchange, or it may be a stamped paper. Any registered document can be a bill of exchange. A check is a different thing. A check has a personal liability. So a person who holds the check, all right, and the person who draws the check, he has the personal liability to pay the particular person that particular amount.
Any more questions? So yeah, I think too many questions we have taken.
Yes.
All right, sir.
Sir,
Yeah.
one more last question from my end, actually. Sir, I already asked if a defendant doesn't receive someone, then what should do? Okay, so you tell me that we need issuing remedy, but if after issuing a non-bailable warrant, if he doesn't, police unable to find him, then what would be the next remedy, sir?
See, these are all procedural remedies. You as a litigant will not have a remedy. Practically, if NBWs are issued and police is unable to find, that's the work of police. They will have to find it. Even if he is in hell, they will have to drag him.
Yeah, sir. Because why I'm asking this question? Because under section 138 there is we haven't any provision
Yes,
to produce him before the court.
yes.
So if police unable to find, and if even if court doesn't direct the police to register complaint under section 420 IPC or some relevant provision in BNS. So that is why I'm asking this question. If police unable to find him,
Yes, yes,
then
yes.
what would be the next remedy?
We can go in other statutes as well, but that is not related to NI Act. In NI Act, you won't have a remedy. All right. So since we are sticking to it, otherwise, I already told that there is a civil liability, so you can also file a civil suit to recover that amount. This also happens a lot many times where a person regularly changes his address. So that's an issue, and these are actually the issues that I was also talking about. When you will enter it practically, you will get to know, and that's why there is a lot of pendency of cases for these reasons. Mostly the cases are pending.
Okay, Asif, we will not take any more questions because of the time restraint. You may follow up with
Yes,
the
sir.
further proceedings.
Yes, sir. Yes, sir. So yeah, first of all the interns over here just show a thumbs up because now I am going to just throw the task one for all of you. Yeah, just everyone. All right. Okay. So now, sir has already talked about 138 section of Negotiable Instrument Act. So based on this, I am going to give you your first task.
Sorry
So
to interrupt, Asif.
yes, sir.
Please proceed with the vote of thanks to sir. Because I
Uh,
think sir has given his valuable time to us, and we are really grateful. And now it is all between you and the interns, so you can explain that on your own also.
okay, okay, sir. Okay, sir. You have heard the theory. You have understood the law from a law expert. Now it's time to apply it. Just final reminder, just closing speech for sir. Uh, That was a phenomenal session, sir. I want to just extend a heartfelt love and vote of thanks to Mr. Suvigya Saxena, sir. And thank you for taking time out of your busy schedule. And you didn't just teach us section 138, but like you showed us the heartbeat of the courtroom. Yeah, the way you connected the constitutional aspects with the practical realities of check bounce cases was truly enlightening. I'm sure I speak for all 300 plus interns over here when I say so. Yeah, sir, thank you again very much that you have taken out for precious time to join us this session. Thank you very much.
Thank you so much. Thank you for all your kind words. Uh, I am really thankful for this opportunity to Nyayavani and the entire team, to all the interns. If you will have any doubts, you can just contact Asif, and if that is possible, we can work on it. All right. So thank you so much.
Yes.
Can I leave now
Yeah,
with your
sure, sir, you
permission?
can leave.
All
Yes,
right.
sir. Yes, sir.
All right. All right. Thank you so much.
Yes, most welcome, sir. All right, interns, you are not requested to leave right now because I am going to give you task one. All right. So, yeah. Uh, First of all, you have heard the theory, you have understood the law from an expert. Yeah. So the first task is very interesting because this time the task doesn't only include all the proofs in single document. I have make it more interesting. The case file is about Mr. Rajiv Rutra, the client, with the broken promise and the bounce check. Is waiting in your WhatsApp groups. Remember what Saxena sir taught you today about the timelines and evidence. Focus on this, okay? And remember the story I told you about the admission update on WhatsApp, okay? Connect the dots. And if then also you found any problem, then you just connect over me, okay? I'm just sending you the sample draft before sending the task. Just go through it thoroughly, okay, and check whether you are facing any problem or not. Then after about 15 minutes I will forwarding the task one and all the document approves. And again I am saying, do not let the AI do your thinking. All right. Once again, somebody was asking about the what's we have to do in the AI. Yesterday you have been taught how to use JustEase website. Okay, go over there and like put this document or give a upload the tax one document over there and just ask that give a prompt over there to draft me or to format me this legal notice, and you will be taking out those notice into your Word document and you will be applying your skill over there. All right. And if you don't want, if you want to apply your old skill as whole, then it's no problem at all. But remember one thing, do not let the AI do your thinking. Okay. Use just research, use it to frame, but let your human mind make the final decision. Yeah, we are looking for lawyers, not the robots. All right. So okay. So the task drops down today, and the deadline for today's task is Saturday, 12 p.m. And no extension, no excuses. You all are lawyers, so time matters the most. So let's make the first week count and let's get justice for Mr. Lutra. All right. Thank you everyone for joining and get to work and good luck.
Before we conclude, folks, we have shared the link of JustEase in your WhatsApp group, in the common group of interns. Just check it once, and then you all know what to do. We had the tutorial session yesterday. If you missed that, you can again access that on your YouTube channel, Nyayavani Foundation. And Asif Khan has already covered all the aspects of your internship. Just make sure that you submitted your assignments, all the assignments on time. Okay, that's all from my side. Best wishes to for your first task, folks. All the best. Do your best to it, and make sure it's a good learning journey for you.
Sir, just want out from me that there was many interns facing issue on joining, so they are asking for the recordings. Will they be getting?
Okay, we will providing them the recordings, or we will upload this on YouTube. Okay, so that it will
Yeah.
be accessible for all.
Okay, okay. Interns, I will be sharing the PPT. Okay, many of you asked for, and the link will be given by Deepak sir, our director. And then I will be following this. I will drop down a sample draft, go through that thoroughly, and after 15 minutes, I will be giving you your first task. Best of luck for your first week task. Sir, I'm concluding the meeting.
Okay, shall I end this from my side?
Yes, sir, you went from your side, sir.
Okay.